Hi, and thanks for tuning in. I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City, and today I'll be walking you through a situation that causes a lot of confusion for Canadians visiting the US. Specifically, how long are they allowed to stay when they enter the US and aren't given any proof of their entry or when they need to leave? And how can they apply for immigration benefits inside the US without these documents? Stay tuned to learn more, and in the meantime, be sure to click the subscribe button. By doing so, you'll stay updated on the most current and high-quality information about options to visit, work, or live in the United States. So let's get back to our question and try to better understand what's going on when a Canadian enters the United States. To start, we need to first understand that Canadians, in general, are visa exempt. This means they usually don't need a visa to enter the United States. Being exempt from needing a visa is different from the Visa Waiver Program, which is sometimes referred to as ESTA. Canada does not participate in the Visa Waiver Program. Instead, its citizens are visa exempt. Since they don't need to apply for a visa in the first place, there's no visa requirement that needs to be waived for Canadians. A quick side note, one of the few visas that Canadians are not exempt from is the E1 Treaty Trader Visa and the E2 Treaty Investor Visa. A Canadian who wants to enter the US in either E1 or E2 status would need to receive the visa before entering the US. But otherwise, for most other visa options, a Canadian can apply at the port of entry. Of course, this is in contrast to almost every other country on the planet. For citizens of those countries, they must be granted a visa at a consulate or be approved through ESTA if they are a national of a Visa Waiver Program country. Then, when they enter the US, US Customs and Border Protection, or CBP, issues them a Form I-94, which conveniently shows them the date by which they must leave the US. If they stay past their I-94 admit until date without applying for an extension, a change, or an adjustment of status, they begin to accrue unlawful presence, which can have big consequences, including being barred from re-entering the US. But because Canadians are visa exempt, they oftentimes are not issued a Form I-94. That means they have no idea how long they can stay in the US before they start accruing unlawful presence. The government calls these individuals non-controlled Canadians. Now, not all Canadians who enter the US are non-controlled, meaning certain categories of Canadians who enter the US do receive an I-94. For example, Canadians who enter by air or sea usually receive a Form I-94, as do Canadians who apply for and enter on a B1 or a B2 visa. Similarly, Canadians who enter in TN status are usually issued a Form I-94. So let's turn to the question you're probably wondering about if you're watching this video. How long can a non-controlled Canadian stay in the US before they start accruing unlawful presence? Maybe not surprisingly, the US government has not come up with an answer that it agrees on. US Citizenship and Immigration Services, or USCIS, and the US Department of State consider non-controlled Canadians to not accrue unlawful presence for as long as they maintain their status. In other words, according to USCIS and the Department of State, a non-controlled Canadian is allowed to stay in the US for as long as they comply with all the terms and conditions of their status. However, CBP disagrees with USCIS and the Department of State. CBP believes that non-controlled Canadians are limited to a stay of 6 months. After 6 months, and assuming the Canadian has not extended, changed, or adjusted their status, they would begin accumulating unlawful presence. So here's the key takeaway. Canadians who enter the US by land but are not issued an I-94 should assume that they're allowed to stay in the US for 6 months, and that they'll begin accruing unlawful presence after that date unless they timely apply with USCIS to extend, change, or adjust their status. Before we wrap up, there's one more question we need to answer. Because as soon as we start preparing the application to extend, change, or adjust status, we run into another problem. USCIS will want proof of when the applicant entered the US in the form of the most recent Form I-94. And if CBP didn't issue an I-94, we don't have that proof. So how can a non-controlled Canadian prove when they last entered the US? Fortunately, the government has stated that non-controlled Canadians who did not receive a Form I-94 can instead provide a detailed affidavit that explains when, where, and how they most recently entered the U.S. The affidavit can be signed by the applicant, and it's recommended that it be supported with additional documents, such as receipts for transportation, fuel, a hotel, or any food or other items purchased at the time the person last entered the U.S. Also, even if the individual did not receive a Form I-94, it's still worth checking whether the entry is listed on CBP's website under the visitor's travel history. We'll include a link to that website in the notes. If the most recent entry is shown in the travel history, it's worth providing a screenshot of the travel history along with the detailed affidavit and any other documentation demonstrating the date of entry. U.S. immigration law is rarely straightforward, and this is unfortunately the case even for our neighbors to the north. We hope this video was helpful. If it was, please go ahead and click the like and subscribe buttons to stay updated on future videos about visa options and travel to the U.S. Thank you for watching.